Okay, so I'm Brenda Speer. This is my business associate, Danette, Lilja. We practice law together at BL Speer Associates.
Gotcha. Okay.
And we do.
Sorry, I should have known.
No, that's okay. That's okay. That's a perfectly legit question. I didn't even do an introduction. You were here today at COPPeR. Anyway, so one of the things, so the area that we practice is known as intellectual property law, which covers patent, trademark, and copyright work. So to give you a little bit of foundation before we launch into just trademarks themselves, again, this is repeat for you guys, but under the law, ideas and concepts in and of themselves are not protectable. So ideas and thoughts in your head, amorphous concepts are not protectable. Ideas are not protectable in and of themselves. What is protectable is the tangible expression of an idea. So you have to have whatever your concept is in your head, get it out of your head into some other tangible format, and then at that point that would be known as intellectual property, and it may be subject to legal protection. So what I mean by that is if you have an idea for a painting in your head, if you have an idea for a series of photographs that you want to go take and compile into a coffee book, that's just abstract concept at that point, and there's no way you can protect it. So if your thought is, you know, I want to go around and take a bunch of pictures of all the historical buildings in downtown Colorado Springs and compile it into a coffee book, and then a month later you go into a bookstore and you see one and you go, hey, they stole my idea. Well, somebody else had that same idea, and there would not be anything you could do to go against that person and say, hey, you stole my idea to take pictures of all the historic buildings. It's only if you actually had photos and they reproduced your photos without your permission, that sort of thing. So what is intellectual property? Tangible expression, get it out of your head, some form of expression of creative human endeavor. And there's 4 things that fall under the umbrella term of IP, and that's patents, trademarks, copyrights, and trade secrets. And today we're just going to talk about trademarks. And I went over this last week too. So one thing that's confusing for a lot of people is the terms patent, trademark, and copyright. And they're different types of intellectual property law, and they're not synonyms. They cover different things that you can protect. So by way of analogy, the term intellectual property is akin to the term transportation. And there's various forms of transportation. So you have cars that drive on land, ships that sail on water, planes that fly in the air, and then sometimes you have overlap, like a hydroplane that can fly in the air and land and take off on water. And it's the same thing with intellectual property law. So patents are different from trademarks from copyright. Patents apply to inventions or discoveries. Trademarks are indicators of source or origin. We're going to go into that in detail tonight. Copyrights apply to original works of authorship. You guys were here last week. You got to hear about that. Unfortunately, you missed out on that one. And trade secrets apply to confidential information. So what are trademarks? Trademarks indicate the source or origin of a good or service. So the purpose of a trademark, the function of a trademark is to set expectations and to do education to consumers. So when we go out into the marketplace and we see an Audi versus a Volkswagen versus a Saturn, what have you, we have a certain expectation as to things like who's the manufacturer, where can we go buy one, what would the price point be, what kind of quality do we expect to get out of it. Trademarks may consist of a number of different things. So trademarks can be words. So it can be Coca-Cola, and it can be words in and of themselves, whether or not they're stylized. So this is stylized words with a distinctive Coca-Cola script. So part of what Coca-Cola can protect with a mark like this is not only just the words Coca-Cola, no matter how they're written out, if somebody else were to try to use Coca-Cola and attach that to their products, but also maybe somebody who takes the same distinctive script and maybe changes the words or some of the lettering a little bit so that your first visual impression is that it looks exactly the same. That could be trademark infringement by a third party. Yes, ma'am?
Wouldn't that be considered a logo? That Coca-Cola?
Right, so trademarks, logos, brands,
okay.
It's all the same legal concept. They're all called trademarks, and they can consist of different things. Words, like I said, just written out or with stylized design. It can be phrases, slogans, taglines, things like that. It's the real thing. Just do it. Barfig Nugan. Can be designs. So a trademark could be a two-dimensional design like this, like the Powerade label. And these are all products in the Coca-Cola line. So the two-dimensional graphic design of the letter P, Powerade, or it can also be three-dimensional. The Coca-Cola bottle itself, the shape of the Coca-Cola bottle itself is also functioning as a trademark. So if another competitor were to come on the market and start bottling a beverage in a bottle of this exact same shape, Coca-Cola is going to come after them for trademark infringement, because as consumers, we see that. We associate that with Coca-Cola, that three-dimensional appearance. It can be combinations thereof. So we've got words, Coca-Cola, we've got a phrase, enjoy Coca-Cola, we've got a two-dimensional graphic design. And we have the little signature wave. Trademarks can also be scents, sounds, and colors. Scents, I haven't seen any scents. Sounds funny. I haven't seen any, smelled any scents in terms of connections with products as trademarks in the marketplace as a consumer, but I dug through the U.S. Trademark Office records, and I found that Smead, the office supply company, they have a bunch of scent trademarks as attached to different office supplies. So they had vanilla and some other stuff, like vanilla impregnated file folders. I've never ever seen them in the marketplace, but they have trademark registration for it. They can also be sounds. The NBC chimes, doom, doom, doom. So you hear that, you know you're listening to NBC. And it can be colors. Like a color can function as a trademark as long as the color is not a dictation of the function of the good itself. So for example, with the Corning insulation, they chose to color their insulation pink to make it distinctive in the marketplace and immediately visible, a visual impact connection to a consumer when they see it. So you see pink insulation, well, you may or may not know, but it comes from Corning. So the pink, but if the insulation was pink because it had something to do with the materials that were used or the manufacturing process, then pink would not be functioning as a trademark. So it's color that's arbitrarily applied to specifically address and identify their goods. Usually, also you see color used in another related area of law called trade dress. Examples there is UPS in the color brown. So all of their uniforms, their delivery trucks, everything have that uniform color brown. John Deere farming implements, they actually have some trademark registrations on their green and yellow color combinations as used on their farming equipment. So trademarks. This is a little grammar lesson for you. Trademarks should always be used as an adjective. So you have, if you were to fill it in a blank, you have a trademark, brand, noun. So you have a Big Chief brand writing tablet. Harking back to grammar school. Trademarks should not be used as nouns. Please make a Xerox of this document. You could make a Xerox brand photocopy of this document. You could make a photocopy of this document on a Xerox machine. You're not making a Xerox. You don't want to use a trademark as a verb. Let's go rollerblading in the park. Rollerblade is actually a trademark for a brand of inline skates with the 4 wheels and a line. And there's 2 reasons why you want to use trademarks always as an adjective. It depends on whether you're the owner or not the owner. But if you're the owner, the reason you always want to use it in this function is because that ensures and carries over your legal protection in your mark. As soon as you stop using your mark as an adjective and it falls into the vernacular and it starts getting used as a noun or a verb, just Google that. Can you get me a Kleenex? I'm wearing my Levi's. Those are all improper uses of trademarks. When they fall into the vernacular like that, or if they fall into the vernacular like that, they suffer a death under the law known as genericide, and the trademark rights fall away. So words that we use every day that at one point were trademarks that fell into the vernacular that suffer genericide are things like escalator, thermos, aspirin. So part of the reason I chose Xerox, and I haven't seen this in a while, but Xerox and Kleenex have frequently done consumer education campaigns where they talk about the proper way to use their mark, and that's because they're trying to prevent their marks dying through genericide and losing any trademark status for the term Kleenex or the term Xerox. Google is one that I find pretty fascinating, and I'm kind of curious what's going to happen with them over time, because people don't say search for that on the internet or use the Yahoo search engine or the Google search engine or anything like that. They're all using Google as a verb now. Just Google that.
I suppose, though, the financial gain that you have by your trademark becoming that well known probably compensates.
Yes and no, because if it gets used as a verb all the time, and other people want to start using it, and Google tries to sue them for, so they say, you can Google that on Yahoo, or Yahoo starts saying, well, just Google it on Yahoo, in a verb sense versus as an adjective, and let's say Google sues them for trademark infringement, if Yahoo can establish that it's fallen into the vernacular and people think of Google as a generic way to say search, use a search engine on the internet versus a particular company that provides search algorithms, then
it's like they have to use that term because it's fallen into the linguistic, into the lexicon of the culture.
And if it does, then it's no longer proprietary to them. That can happen, yeah. And so the other reason you care is, one, as an owner, you want to make sure you use your own mark properly, and two, from a fair use perspective, I assume most everybody here does something creative. What sorts of creative endeavors do you do? Give me art, painting, and yourself? Jewelry, and
a
sculptor. Okay, so you guys probably don't encounter this as much as I do with my creatives who write, because I get asked a lot, well, can I use trademarks in my writing? And part of this whole thing here is, well, if you use it properly, you're probably okay. So for instance, we're talking about the vernacular. If somebody wants to say, you know, the heroine sobbed into her Kleenex, I would say, unless Kleenex is key to what you're writing about, you don't want to do that. Just have them cry into a tissue, or if it's really that important, have her cry into a Kleenex tissue so that you're using it properly so the trademark owners stay happy. There's various types of trademarks, and I'm going to talk about them in terms of ascending legal strength. So from things that are legally weak to things that are legally strong. And part of the reason I want to talk about this is because there's an intersection between what's a good mark in the world of marketing and what's a good trademark in the world of law. And if you were to graph them, you know, your XY coordinates, they would intersect like this. So the types of marks that marketers love, and Danette's former career, one of her careers has been in the world of marketing. The types of marks that marketers love, trademark attorneys hate. Because, so starting at the bottom of the heap, things that cannot be trademarks. Anything that's generic. So anything that's generic cannot be a trademark. And I don't mean a generic word. What I mean is, if you sell cars, you cannot say that car is my trademark for the actual good itself. So there's no way it can function as a trademark. It's got to be a term that's available for everybody to use. Same thing on the service side. So a trademark can be, a trademark is just a term that is used with goods, and service marks are used with services, but they're all trademarks. At the bottom of the rung, in terms of what's legally protectable, but what marketing types really like, are what are known as descriptive trademarks. And these are trademarks that merely describe the nature or quality of the good or service. And here's an example, half-price books. So when you see that, the reason marketers love it, what do you immediately think when you see that?
All the books are going to be half price.
All the books are going to be half price. They're bargain rates. I'm not paying full retail. It's a good deal. Woohoo! Marketers love that. Immediately, consumer connection and education. Nothing further really required to educate the consumer as to what those goods are or benefits they would derive. But as attorneys, we don't like those. Because the law looks at these as, well, these are all terms, for the most part, that should be available for anybody to use in connection with their goods and services. So from a legal standpoint, things like this, descriptive marks, are hard to get registrations for. They're harder to enforce trademark rights and protection on behalf of your client against people who might be using the same or similar marks. If I'm going, I feel like I'm talking really fast, so if I am, I'll try to slow down. Suggestive trademarks are marks that, so they're a little bit up the rung from descriptive. They suggest the nature or quality of the good or service. So they're not immediately telling us it's a half-price book. They're suggesting something to us. There's more of an implication underlying there. So back in the day when Coppertone first came out, this was a suggestive mark because it's suggesting, use this product, you'll get a beautiful tan. Another mark, Edge, for shaving cream. So there's a suggestion, use Edge, you're going to get a nice close shave. It's not saying close shave shaving cream or anything like that. Now these are, marketers still like these types of marks, but they're not as favorable because there's a little more consumer education that goes along with launching a product. So if you're brand new in the marketplace and you're Edge shaving cream, the consumer seeing Edge is not going to necessarily automatically connect that mark with the good. Arbitrary trademarks. are marks in which you take an existing term and you arbitrarily apply it to something else that's unrelated. So for example, Apple. So Apple is an existing term, but it was arbitrarily applied in conjunction with computers and other electronic products. So they're not actually selling apples, but that was what they chose to use in conjunction with their computers. And one of the things that I think about Apple too is I also think it's suggestive, and I think maybe one of the reasons why they settled on this mark is because one of their initial market targets was the educational market, and that whole concept of you take an apple to the teacher. BlackBerry. So this is another arbitrary application to a product. I think part of how BlackBerry came about though was because of the little button keys on the phones. And again, so going up the curve, good from a legal standpoint, going down the curve, a little weaker from a marketing standpoint because it requires more educational, consumer education and advertising campaigns to educate consumers as to what these products are.
So Apple couldn't sue BlackBerry for saying, hey, we already used a fruit, that's
No.
copying.
No.
No. Okay.
And we'll talk about that a little bit further when we get a little bit further in here. So next up the rung is what is known as a coined or a fanciful trademark, and these are the legally strongest trademarks that you can possibly have. And a coined or a fanciful mark is something that's made up that never existed before. So we're not taking a word like Apple that already exists, but applying it in another context. Kodak was a word that was made up, never existed before. Xerox, made up word. Exxon is another example of marks that were created from whole cloth. So, okay, so you got a trademark. What do you get for that? What you get with a trademark is the exclusive right to use your mark with your particular goods and services. And this is part of what you were asking about. So you get exclusive right to use your mark, your particular goods and services, not anything and everything under the sun, unless you're a hugely famous mark like Coca-Cola or McDonald's. They can pretty much keep everybody out of everything. But when I say your particular goods and services, an example here, Dove. Dove is a trademark that's used in conjunction with beauty products, shampoo, soap, etc. And Dove is also a trademark used in conjunction with chocolate and candy. Two completely separate, unrelated companies, same mark, disparate goods. That's perfectly okay. They each have the right to use their mark, Dove, with their particular products, cosmetics, candy. So once you have a trademark, to what extent can you extend and enforce your rights? Well, one thing that's good about trademarks is all you need to do to establish trademark protection is to start to use your mark in conjunction with your goods and services in commerce. And a use, from a legal standpoint, is anything that is either an offer to engage in commerce or sales transaction or an actual sales transaction. So what I mean by that is, let's say you're starting a new business and your mark's, now I can't even think of anything, but let's just use Dove. You were going to start in a candy store and Dove was going to be the mark. If you go rent space, retail space, to sell your wares, and your company name maybe is Dove Incorporated, and you sign that lease as Dove Incorporated, that's not using your trademark because you're not engaged in commerce in connection with your goods, actually selling candy. You hire a sign company to come out and hang a sign on the front of the building. You're still not in use in commerce yet. But if you have all your inventory stocked and you have the sign up and you turn the lock on the door and you open the door and consumers can come in and buy chocolate from you, now you're using your mark. So that's what I mean by using your mark with your goods in commerce.
But what about on the internet, like say a website?
And a website, it sort of depends. So basically you need to be ready, willing, and able to fulfill a transaction. So if you
have a shopping cart and they can purchase it.
And they can purchase, then yes, then that would be considered a sales transaction. And it may not necessarily even have to be an e-commerce enabled. I mean, so let's say you're advertising your painting and your art on your website, but there's no checkout cart. But if you say, here's an original painting, it's $250, call me if you want to buy it. So you have the product there, you're ready to sell it. Then you would be using your mark, your studio name, or what have you in conjunction with your goods on your website.
Okay, well I do have an e-commerce website where they can purchase.
So I would say then yes, you're using e-commerce. So it doesn't have to be physical space. Right. It has to be, you just have to be using your goods, your mark with your goods and services in commerce. And web presence typically equates to that, but provided you're ready, willing, and able. So if you just had a URL and you had like a parked page, say maybe, with just contact info, coming soon kind of thing,
Right.
then no, you would still be in that preliminary stage.
I see.
So you start to use your mark with your goods and services in commerce, and that's known as common law usage. So you don't have to do a registration or anything like that. Start to use your mark in commerce, you're accruing trademark rights. The disadvantage.
I have another question.
Okay.
I designed an ear cuff, and I call it the ear wrap, E-A-R-A-P.
Okay.
And I put TM after that. Can I do that?
Yes, because you're starting to use your mark with your goods and services in commerce, and in a couple of slides we'll talk about the difference between the TM and the circle R. So
Okay.
shelve that for just a second. We'll
Okay.
get to it. But that's a good example. So by doing that, by adopting a brand, trademark, in conjunction with your goods, and making an offer to sell them out there to the public, you're using it in commerce. You're acquiring common law usage rights.
Okay, so that's considered common law
Yep,
usage.
so at this point in time, you're under common law usage. So the advantage is all you gotta do is start. The disadvantage is that your trademark rights, so your exclusive right to use your mark with your goods and services, is going to be limited to the territory where you can demonstrate you're engaging in trade. And that's pretty much gonna come down to physical brass tack evidence, like, did you sell a pair of ear wraps to somebody in Colorado Springs? Okay, we could probably say you have trademark rights there. Did you sell a pair to somebody in Fountain? Okay, we could probably say you have trademark rights there. But let's say maybe you have a competitor pop up in Montrose on the western slope, and they're doing the same thing and they're using the same mark. Maybe, maybe not, because at this point you're both going to be somewhat limited by where you're actually engaging in trade, and that's just a fact finding.
If I ship to someone out of state.
And if you ship to someone out of state, it doesn't, under common law usage rights from a legal standpoint, a legal analysis standpoint. So let's say you ship to Wisconsin. That doesn't automatically now get you the entire state of Wisconsin. It might give you whatever little area you're shipping to in Wisconsin. So you could have a map and you could have this little area and that little area and this little area.
I see, okay.
But if you want to increase your protection, you can start going up the rung. And the next level up is a state registration. So to qualify for a state registration, you need to use your mark with your goods and services in the state where you're going to register. The benefit that you get with a state registration is a presumption attaches that you're using the mark throughout that entire state, whether you have an actual presence throughout that entire state. So the example I had before, if we register ear wraps in Colorado, and you've sold a pair in Colorado Springs, but you haven't in Montrose, it doesn't matter, because by virtue of your registration, that legal presumption attaches that you have the right, you have the exclusive right to use it throughout Colorado. So if you had a competitor pop up later, you could use your state registration against them to prevent them from using the same similar mark with the same goods and services.
So who do you register with?
And state registrations are done through the Secretary of State, and it's state by state.
And there's a fee for that?
And there's a fee for that, and it varies by state. Next up the rung of protection is a federal registration. So in the United States, so this would be a US registration at the federal level, to qualify for a federal registration, you need to use your mark across state lines. So in your example earlier again, so you're in Colorado and you sell a pair of your ear wraps to somebody in Wisconsin, you've had a transaction that crosses state lines, that would qualify you for federal registration. The benefit of a federal registration is now that evidentiary presumption of where do you get to use it extends to all 50 states and the US territories, whether you're physically engaged in commerce in each state or not. As long as you're in 2, you can potentially scoop up all 50. And the reason this is important is because if you're relying on common law usage rights, you're just acquiring territory piece by piece by piece. And trademark rights accrue to whoever uses first. So if you're first, but you're in a little territory, somebody else can pop up second in a separate territory, assuming you're both relying on common law usage rights, and that's perfectly okay. But once you cross over into each other's territory, you have to adopt different marks.
But what if you both have been using common law?
If you've both been using
And
common law, then at that point, you
state register or you federal register.
If you-
Whoever registers first gets.
to a certain extent, but really technically, you would still be limited by whatever territory you're going to. So let's say you have ear reps in Colorado, somebody has ear reps in Maine, and you're doing the same thing, and you're both relying on common law usage. The problem is, to also qualify for a federal registration, you have to be the first and only user of the mark. So now neither of you would be able to do a federal, legally, technically.
Okay.
You would both then be gobbling up territory state by state, basically.
We had this exact thing going on with our furniture business when I was Country Classics is what it was called, and we were registered with the state, and we were Country Classics in the state of Colorado. We actually had to go get the name from someone that we knew in Denver, and even though they were using it, had to go have them sign it. They quit using it, we took. But there were Country Classic furniture all over the place.
Right.
In Wisconsin. And occasionally we get their rugs, they cheat us. I mean, it's just crazy stuff coming left and right. So we changed it to Colorado Classics. But the state registration worked real well. It was under a corporation. So to do federal, you have to be in 2 states. You have to be registered in 2 states.
No, you have to be, to qualify in terms of the rules of doing an application to try to get a federal registration, you have to be engaged in commerce across state lines, at least 2 states.
So you have to have a location and be involved.
You don't necessarily have to have a location. So in your example, you have a physical storefront.
Right.
If you still had a customer out of state purchase from you and you shipped to them under your mark, your name, your goods and services, that would qualify as a transaction that crosses state lines, and you could qualify for a federal registration.
Now, would you be Country Classics of Colorado would stand different in a different category, which is Country Classics in Wisconsin or Nebraska or wherever?
From the dog will limp. No, it's in a situation like that, Country Classics, where it's something that's more common. Unfortunately, you and your competitors were sort of all on equally bad footing in terms of trying to enforce your rights against each other. So if you're Country Classics of Colorado, it helps some, but not necessarily a lot in terms of if you were trying to shut somebody down somewhere else. So the tag on of additional descriptive terms don't necessarily help you a whole lot from a trademark protection standpoint. So it's like people say, oh, well, Country Classics is already registered. I'll be the Country Classics. Well, from a trademark law perspective, it's a difference without a distinction. So yeah, the Country Classics and Country Classics are technically different, but in the eyes of trademark law, they are not. They're the same thing. And we'll talk about that here in a little bit. So your trademark rights are going to last under common law usage, no matter what type of usage rights that you have. But as long as you use the mark continuously with your goods and services, your trademark rights will last. So trademarks are probably one of the most powerful intellectual property rights because they last of infinite duration. Patents have a set term, copyrights have a set term. Trademark rights, though, can last and last and last. Again, Coca-Cola, 150 plus years, the same mark in the marketplace. Now, state registrations are typically either a 5-year or a 10-year term, and it varies state by state. And that registration is good as long as, one, you keep your term renewed and up to date, and you continuously use the mark. So what happens is, if you have a state registration, and in Colorado it's now a 5-year term. It changed a couple of years ago. It used to be 10, and then it was lowered to 5. But let's say you have a state registration here in Colorado, and you let it lapse and you don't renew it, then guess what happens? You fall back to common law usage rights. So you're not necessarily out your trademark, but you're out this weapon in your arsenal of your state registration, granting you an evidentiary presumption you're throughout the entire state of Colorado, and you might wind up falling back to this patchwork quilt territory carve-out situation.
But if you have federal registration, does that cover the state?
And you have a federal registration. It covers all 50 states, and your federal registration is going to be good for 10 years.
Okay.
but provided you continuously use. So no matter what you do, as long as your mark's continually used, you have trademark rights.
Do you have to have the state if you have the federal?
No. However, depending on what you're trying to accomplish from a business standpoint, just because you don't qualify for a federal registration right away doesn't mean that you would forego ever filing for a federal or never file a state. And here's why, because we were talking about trademark rights accrue to whoever is first, the senior user in the marketplace. So in your situation, hypothetical potential person out there, if you did a Colorado state registration because your business presence is just in Colorado for now, fine, we do the Colorado state registration. Maybe 2-3 years from now, as your market starts to expand, it makes sense to go through the expense and pursue a federal registration. Well, what should happen is if somebody pops up in another state and they want to go apply for a federal registration, by virtue of your state registration being there first, the state of Colorado is already gone, there's no way a federal registration can ever attach to the junior or the latecomer to the marketplace, because that federal registration is supposed to cover all 50 states. One of those states is already gone. So it could be a good offensive move to do a state registration, or even 1 or 2 states if you're just in a regional territory. So it just depends on the situation. I mean, I've had clients like you were talking about with your Country Classic example, where they have been a competitor, same mark, same type of good or services, but in another regional area of the country. So neither of them could do federal, but it's like, all right, let's just go state by state where your primary marketplace is. And you can carve that out, and then if your competitor ever comes to your territory, they're going to have to adopt a new mark. They're going to have to come up with something different.
That's going to be interesting. Example, again, American Furniture Warehouse. There's one here, there's one in Albuquerque. American Furniture in Albuquerque, both established, well, Albuquerque is a 70-year-old company. American Furniture Warehouse is about 35, 36. But they run over each other all the time on southern Colorado and New Mexico.
Yeah, and and that's another example of, as a trademark attorney, not a fan of those marks.
Yeah.
Because they're weaker. But from a marketing standpoint, America makes us all feel warm and fuzzy and patriotic, and they must be good corporate citizens and all that kind of fun stuff. So I understand the appeal from a marketing and a consumer standpoint, but from an attorney standpoint, I'm like, not so good.
Yeah.
It creates issues as you grow.
So 2 really basic questions, Brenda.
Yes.
You register for a federal trademark through the U.S. Patent Office, or what?
Yes,
agency?
the federal registration is done through the U.S. Trademark Office.
U.S. Trademark Office, and then...
Well, it's the Patent and the Trademark Office. It's 2 divisions in one, yeah.
And what serves as proof? Just your bank records that you processed payment from out of state, or your shipping records, or what?
So in terms of what you would need to submit to the Trademark Office, the proof that they're relying on are your statements stated under oath in your application. And there are some, what is called a specimen or a sample that shows you using your mark in conjunction with your goods and services. But they are not looking for further evidentiary proof of when you launched and started to use your mark. However, you still need that, because if you were to get into a battle with somebody over who used first, that would be part of the evidence in your arsenal to establish your track record of when you really started to use your mark. So although it's not anything you have to submit to the Trademark Office, you still need it, you still want that backup in place.
So we should keep records of a few sales from each year or something? Or?
Yeah, so you're going to have an invoice record, you're going to have something somewhere that's going to show when you launched. And that's part of something you can tuck away in your little file. Here's my invoice with my first sale, and a couple of printed labels. I don't know, say it was something that lent itself to a label being on it. Just file that away. So trademarks, they last as long as you continually use them, but once you stop using them, they can fall into the public domain, which means somebody else can come along and adopt that same mark with the same type of goods and services as the person who abandoned it and claim trademark rights in it, starting fresh with their usage going forward in time. But in terms of how long does something have to be out of use, in terms of And this is not a hard and fast rule, but this is just the general rule that's grown up over years of litigation in the trademark arena. But generally, a trademark has to lie fallow or be abandoned for 3 years. So typically, if something hasn't been used for 3 years, for the most part, it's probably going to be okay to scoop up if you want to scoop it up. And this is the sort of things that, I can't think of any examples right now, but companies do fight about this, or they'll do some sort of retro marketing blast. And the reason they're doing that is they're trying to pull out some trademark that's in their stable but they haven't been using and dump it out there and use it so that so it's not going to become abandoned. That came up in the arena somewhere recently. Can't think of what it was, with relation to cars. Model names for cars, I forget. Anyway, so part of the question that you were asking earlier about, so what do I use with my mark ear wraps? So when you see this R in a circle, that's an indication that you have that trademark owner actually has a federal registration for that mark. So that's what R in a circle indicates. A TM or an SM, if it was a service mark versus a mark used with a good, a trademark, indicates either somebody who has a state registration or they're asserting a claim of common law usage rights.
Yeah, that's what I'm doing now.
So that's what you're doing. So at this point, you're asserting, I have common law usage rights. So I'm putting people on notice by using the little TM marking with it that I think this is a mark that's unique to me and I think I have the right to use it and I'm asserting common law usage rights. So as a caveat here, don't use R in a circle just because you think it looks really cool and it might dissuade others from trying to adopt the same or similar mark, because there can be civil and criminal penalties for using that if you truly do not have a federal registration in place. So and I'll pick on graphic designers a little bit. Sometimes they get a little R happy. They stamp everything with R for their clients, even though it might not apply yet.
I was just wondering if using the TM was illegal.
No, the TM is perfectly okay. Stay away from circle R unless you have a federal registration behind it. So TM or SM are okay. So acquiring rights, like we talked about, as soon as you use it in commerce, if you want to do a registration at the federal level, you go to the U.S. Patent and Trademark Office. If you're doing a state registration, it's to the Secretary of State of that applicable state. So a Colorado registration filed with the Colorado Secretary of State, Wisconsin Secretary of State, etc. So as we've been talking about, a registration is not required, but a registration is a good thing to have. One, it's proof of your rights. Two, it's proof of your ownership. And most importantly, it's public record. So if you have a federal registration or even a state registration on file, that's considered a public record. So let's say we do a state registration for ear wraps, assuming it's an available mark. So the world is considered more or less put on notice now that you claim exclusive rights to use your mark with your jewelry, whether or not those people ever looked at that record or not. So if you did have somebody in the state of Colorado on the western slope start to use the same thing, we go knock on their door with your registration and say, hi, sorry, got to get something else. And if they say, well, I didn't know, it doesn't matter. It's public record out there. So again, I'm assuming you guys are creatives. Well, yeah, I don't know. You guys probably aren't very creative.
No.
No, not at all? Totally?
No,
No, I'm just kidding. I'm just kidding. I'm just picking on you because you're in the back row. But so what type of things can be trademarks for creative? Well, just about anything and everything. So you have a really good example of ear wraps is used in conjunction with your jewelry. You have a physical store with inventory of furniture, well, now Colorado classics. So it could be your studio name. If you're a writer or publisher, it could be the publishing imprint, like Random House versus Penguin versus whatever. Again, for writers, series of books, titles of series of books like Dummies, Idiot's Guide, Fodor's, Travel Guides. That's a title of a series of books. Those can be protected as trademarks, but a one-off title cannot be, if I'm making sense. Any kind of product line. So your Procter & Gamble. You've got Bounty towels, you've got Crest toothpaste, you have Tide detergent. So you can have a stable of trademarks brands used with various and different products that you have. Oh, I'm missing some stuff here. Oh, okay, here's the important stuff. All right, so we talked about genericide. Want to use that in your proper format so you don't lose your trademark rights. Pick a good mark. You want a legally weak mark. They're hard to get registrations for, and they're hard to enforce your rights against other people, so they're hard to protect. Here's a really, 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 really hugely important one that we just ran into in our office in the last day or two. You want to clear a mark before you launch a product line and put it out there in the marketplace. Why? Why do we care? Because the trademark owner has a right to use their exclusive mark with their particular goods and services in commerce. And those rights accrue to whoever's first in the marketplace. So do you want to do a product launch and not know that you're first or that you're cleared to use the mark? So, okay, so who really cares? What if you're not first? Oh, they're going to come knock on my door and tell me to stop using it. Yeah, well, let's just assume you don't have legal fees and there's no court costs or anything like that. Let's just talk about down and dirty out-of-pocket costs. So I'm going to pick on you since you gave us an example to work with. So let's say ear wraps is already out there, another jewelry designer using them in conjunction with ear cuffs.
Spelled the way that I spell it, because it's
doesn't have to be exact.
And it doesn't have to be exact, because let's say it's EARWRAP versus RAP. From a trademark infringement perspective, I hope I have that one slide in here. Anyway, so from a trademark infringement perspective, what the courts are looking at is, for trademark infringement, there has to be a likelihood, not an actuality, a likelihood of confusion among consumers as to the source or origin of the good or service. So his example about, we were Country Classics, and we switched to Colorado Classics because we were getting shipments of other people's inventory. That is a classic example that would be used in a trademark dispute of actual confusion. It's not likely that people would be confused. They are actually confused. They're calling the wrong store, they're sending product to the wrong place, they're sending payment to the wrong people. They bought the couch from those guys in Wyoming, yet they sent the check to us, or vice versa. So, so is there a likelihood of confusion? Things that the courts are going to look at are factors like, is there similarity in sight, sound, and meaning of the two marks? So, Country Classics, the Country Classics, difference without a distinction. Ear wraps, WRAP, ear wraps, RAP, similar in sight, sound, and meaning. They sound the same to us, they look pretty much the same. Are they used, they're looking at a host of factors. Are they used with the same or similar goods? Ear wraps with a W, ear wraps without, both with ear cuffs, same goods, similar in sight, sound, and meaning. Yes, that would be a likelihood of confusion. Yes, that's trademark infringement. Whoever's junior user, last to the marketplace, you lose. Victory goes to whoever was there first.
But I don't think anybody has trademarked the word ear wraps. It's two words, EARWRAPS.
So it's ear wraps one word?
It's just
it doesn't matter. So okay, I'm going to say ear wraps to you as two words, ear wraps. I'm going to say ear wraps to you as one word, ear wraps.
It still sounds the same.
I'm going to say ear wraps to you with a W, ear wraps. I'm going to say ear wraps to you with an R, ear wraps. I don't know, I'm just saying. So
well,
ear wraps with an S, with a Z.
Ear wrap. But is that going to be confusing to
The ear wraps and ear wraps. Are they similar in sight, sound, and meaning? Yes. So
it's the ear wrap.
So so any kind of an article in conjunction with a mark from a trademark law standpoint, meaningless.
I see.
Spelling difference, meaningless. A C, an S, a Z, an X.
Okay.
They're all ear wraps, S, ear wraps, Z, ear wraps with an X. It's all the same.
I may not be able to trademark it.
So who knows? I don't know. I'm just saying, again using yours as an example of what could be, are they similar in sight, sound, and meaning? Are they same or similar goods? Are they?
The plus is you don't have to go out there and do your wraps with Z. You know, to trademark it. You don't have to register that with the state of Colorado, in addition to WN.
To every, yeah, so whatever, so if your variant, if yours is EAR, what is it again, EAR?
It's the EAR-AP.
The
No,
EAR-AP, okay, the EAR. So would you need to register every permutation of spelling under the sun? What I'm saying is no, because let's assume your mark is good to go. You're the first. Somebody else comes along and they stick a W in it, or they hyphenate it, or they do it 2 words, or they drop the, or and they use an, or something like that. It's still similar in sight, sound, and meaning. It's still same or similar goods and services. It's still same or similar consumers, channels of trade, price points, the whole shebang. So when you mesh all that together, the junior user has definitely created a likelihood of confusion among consumers, and they would be trademark infringers. So you're the victor, so what does that mean for the junior user? Or if you're the junior user and you're the loser in the analysis, what does that mean? Okay, well now you got to gear back. You got to come up with a new mark and clear it. You have to pull all your inventory out there back, relabel it, reship it, redo your marketing and collateral, re-educate your consumers, all of that stuff. So we had a potential client ask us about doing a federal registration for their mark. They're already in business, they already have several stores launched, they want to go federally. Guess what? Already federally registered. What are you guys doing out there in the marketplace with storefronts up, expanding like crazy, thinking that you're going to get a trademark? Sorry, you're not.
And the backstory.
And not only that, you better change now before they find you.
Right.
Because they're looking.
Because the backstory, I mean, the backstory is this. And I really appreciate your example because it illustrates it perfectly. This is why DIY is detrimental.
Well, and this is why you want to clear before you launch, because if you're the latecomer, it can be really expensive for you. And also DIY, do it yourself, do your own federal registration, do your just willy-nilly go launch and do business. It can be detrimental from a cost standpoint. So, you know, we're going to tell you, well, sorry, not only can you not register, but you got to retool and come up with something else, and then pay to register that, and then we'll clear it first, and then register it, and then change your collateral and take down your size.
And I was talking
All
about
kinds of stuff.
DIY on the clearance part of it.
Yeah.
Because I happen to know, this is my client, that they went and did the preliminary analysis themselves, but they're not attorneys.
Well,
so they didn't understand what they're looking
at.
And they did exactly what you said, which is it's not exactly the same.
Oh, I see.
And there are so many similar marks right now that the analysis is easy from our standpoint because we know what the law is. From their standpoint, they were doing exactly what your example was, which is they were, you know, separating words, changing a letter, but it sounds, tastes, looks, smells exactly the same as what's out
Now
there.
they're getting sued now by someone?
No, well, no.
No, but
to try to prevent that. Right? It's always easier to keep people
But
out of
they put-
trouble than to get them out of trouble.
Right, but what they did was,
But they're already set up.
and you know, this is a frustration we deal with all the time. That I mean, I understand wanting to be cost effective and when money is tight, but there's times when you should spend money, and it's well worth it to hire somebody who knows what they're doing to help you out. So DIY in terms of clearing your own mark without any knowledge of trademark law, and you say, oh, well, I see that there's EARAP already out there for ear cuffs, but I'm just going to stick that W in and it's okay because it's not exactly the same. It means nothing. From a trademark law standpoint, who cares? As a layperson, that may seem perfectly safe, but it's really not. So, you know, you could unfortunately find yourself in a really detrimental position.
If there are oodles of something out there, I mean, lots of iterations, I can't think what it would be.
Then, you know, then that will start to
Flashlights
change the
and-
analysis. That starts to change the trademark analysis, but it's a whole legal analysis that's based on the specific facts of that situation.
Well, if one of those oodles suddenly becomes, you know, big, I'm thinking that everybody's kind of on a level playing field, and they're all kind of out there chomping along. But one of them goes boom for whatever reason. then it becomes a.
And at that point, at that point, I would say they're still out of luck, because just because now their recognition in the marketplace takes off, again from a trademark law perspective, does nothing to further empower their marks above and beyond everybody else when they've all been out there playing in the sandbox together.
Right. So it goes back to the first one.
Well, it's still, or they could all still just have to continue in coexistence, regardless of the fact that one of them's kind of risen up in the eyes of consumer recognition in the marketplace. And then I have the same little slide from last week. Oops, in terms of questions, you know, my little Doug Adams joke. So your answers are either 42 or it depends.
So I guess what you're saying is I should register with the state.
I'm not saying that. So I'm sorry.
No,
probably
already giving you information. We're not giving you advice.
When you file an application for a registration, doesn't the office, the state office, do the research?
No. So here's the issue between.
So they won't give you a registration without.
So right. So here's the issue.
That's problematic.
So this is why, and that's why DIY is detrimental. So right. So all you got to do is use your mark, right? And you start to acquire common law usage rights. How easy is that? But the trademark rights accrue to whoever is first. So that's why clearance is important, whether you're going to rely on common law usage rights or do a state registration or do a federal registration. And as you said, here's the big distinction between Fed and state. At the state level, and this is true in Colorado, and it varies state to state, but basically none of the Secretary of States substantively review a trademark application. They're accepting it on its face. And in the state of Colorado, the amount of detail that the Secretary of State looks at is, at this point, pretty much down to the mechanical level, especially with the era of computers. So really all they care about is if there's one character difference. So again, talking about just the mechanical level of how they do it at the state of Colorado. So let's say you go online and you register EARAP, one word, Colorado Secretary of State. I could file 30 seconds later EAR space AP, and the Secretary of State would take it because it's one character difference. They are not doing any kind of substantive review. That burden is placed upon the users of the system. That doesn't mean just because you registered first and I registered second that we would both have that trademark right, because I would be, if I was your counsel, I'd be saying, look, she's first in time, as shown by her registration. Not only that, evidence file, she's been selling under this mark for a year. You, number 2 with a space, just popped up last night, so you're late, you're the latecomer, you've got to stop. At the federal level, they do substantively review the applications before the registration issues. But even that is within bounds. So they don't have an obligation to go search anywhere and everywhere to see if there's any same or similar marks pending out there in the world at large. So they're still pretty much looking within their own sphere for the most part, which is what's on the records at the U.S. Trademark Office. It's not to say that in terms of having examinations done that I've never had something in a trade journal or a state registration cited against me as part of that review process, but it is not all that common. So the burden is really on the users to clear their mark first and go through the registration process appropriately.
And it's better to hire an attorney.
Definitely.
Review. Okay.
Definitely. Well, with any legal issue, you can always represent yourself.
But if you don't know the law.
But if you don't know, but it's sort of, it's like, you know, the example I give is like when people say, why should I hire you to do it? I can do it myself. I say, that's fine, you're right, you can do it yourself. But if you're going to do it yourself, then you better go educate yourself, because otherwise you're going to do yourself a disservice. And it's just like, yes, I could change the oil in my car, but I do not want to.
Right, exactly.
I don't want to get dirty. I don't want to have to learn where the drain plug is. I don't want to have to learn what kind of filter I got to buy to put back in my car. So I'm going to go pay somebody else to do it. It's, you know.
It used to be easy to do that. It's easier now.
The car I have now, it's like you pop the hood. and there's a little slot for like, you know, putting in windshield washer fluid, and beyond that, it's like the whole thing is just encased. I wouldn't even know where to start. So yeah, it's greatly changed, but
So what is the cost typically of doing such research? I mean, like, how long does this take for?
In terms of, well, it sort of depends on where you are in the process, but to do a state registration in Colorado, it's effective as soon as you file it. And that's pretty much true across the nation because everything's become so much more automated and done online. A federal registration generally takes from about 9 to 18 months from the time you file to the time you have a registration issue. And at the federal level, it's first come, first served. So you file your application, you get in line, you wait your turn for them to actually pick up your application and review it, and then start your journey through the registration process.
No, what I meant is if I choose to hire an attorney to do it.
To do it.
Is this a really expensive thing, or are we talking
hundreds of thousands of dollars
or what?
Firstborn child, one arm, leg below the knee. No, you're probably so I'm going to qualify part of my answer. So the other thing is, in the federal system, and even at the state level too, there's a classification system that groups related goods and related services together. So part of your cost is your filing fee, and you pay a filing fee per class of goods and services that you use your mark with. And so depending on what it is that you sell, you may fall into one class, you may fall into more than one class. So let's just say that you are an author and a speaker, and you're Stephen Covey's 7 Principles of Highly Effective Leaders. He's got books and printed materials, that falls in one class. He has electronic audio materials and CDs, that's another class. He has consulting services, that's another class. He does live speaking for entertainment, that's another class of goods and services. So he would have the 7 principles across 4 classes, so he'd be paying a filing fee in 4 classes. At the federal level, it's $325 per class. So let's just assume you just file in one class of goods. Typically, ballpark, you're probably going to spend about $1,800 to $2,000 between legal fees and filing fees to do a federal registration, and that's assuming there's no bumps in the road. The registration process goes pretty smoothly. And that does not include doing a full-blown search and clearance.
So in my case, I am an artist. I make jewelry, I make sculpture, I paint and draw. I have a logo for my business, a name of my business. Does that count as one class, or is it a different class for every product that I make?
Generally, any kind of jewelry product, although, so let's just say it's jewelry. Okay, see ya, thanks for coming.
You bet.
So let's just say it's jewelry in general. Probably most any item of jewelry is all going to fall in the same class. Even though you would say in your trademark application, you can't just say used with jewelry. You have to say used with jewelry, namely necklaces, rings, earrings, toe cuffs, bracelets, what have you. But if you were using it with jewelry and
stone sculpture,
2 different things.
That's a separate.
I wouldn't swear on that,
class,
but yeah.
Maybe. Okay.
Your stone sculpture is probably going to fall into something different than jewelry.
But in my case, the ear wrap would just pertain to ear cups.
Well, it's jewelry.
It would be jewelry.
It would be
Okay.
jewelry, so it'd be in one
It would
class.
just be jewelry, so
Yeah, right.
it doesn't matter what type of jewelry?
You would still recite what type of jewelry you're using it with. Yeah.
Okay.
Yeah.
So would that be considered 2 classes?
No. All I'm saying is that from a trademark perspective, typically you cannot just use a broad label of what the good is.
Oh, okay.
So we couldn't just use the broad label jewelry. They're going to say what kind of jewelry. So we would be saying we use it with jewelry, namely ear cuffs. You're welcome.
That sounds pretty fun.
Anything else? Any other questions?
I have questions about the copyrights again.
Oh no, we are so done with that.
About how much does it,
I'm just kidding, go ahead.
how much does it cost to register a copyright?
In terms of, I charge a flat fee of $325 to do it from start to finish, and the filing fee is $35, so it's $370.
So is it advisable to get an attorney to do the copyright?
I think so. If you don't understand what you're doing, or you haven't gone through the process before, I think you do want to.
Okay.
Because one of the things that I think makes it tempting for people to do their own work is they say, well, it's just a form to fill out. But what they don't understand is you need the information behind what information and the proper information to put in which blank in the form. And it's the same thing with the copyright registration process. I mean, I'm not going to, woof you. It's not like it's some super horribly technically hard thing to do, but there is still a level of knowledge that goes into doing it and making sure that it's done right and appropriately.
Okay.
So.
And then my second question is, if you design something and somebody takes your design and changes it a percentage, is there a certain percentage?
Nope, there's no such rule. It's every
no-
case is fact specific. So
Okay.
I can't tell you, oh right, in the line of jewelry, if it's 10% or more, it's totally okay. But if it's 9.9, forget it. There's no such rule.
Because I've heard that from other people that they change it
It's
20%.
a piece of artistic folklore.
It's totally,
I've heard
You know, they can
60%,
take
so
your
you know
design
it's changed.
and change it 20%,
Yeah.
and they can, copy your design basically.
well,
if they
in the
change
world
a
of
certain
world of
percentage.
visual art, everybody, people have tried to argue with me all over the board about I swear it's 12% or it's 60 or whatever, and there is no such rule. And the same mythology applies in the world of writing. People want to argue with me and say, if it's under 200 words, it's totally okay. I'm like, well, there's all kinds of stuff that's under 200 words that it is not totally okay to go use it, like poetry.
Yeah, exactly. 4
So-
lines.
Yeah, so it's,
There really is no rule. And
There
there,
really-
that's perpetuated by somebody who's infringing. When people say that, they're justifying their actions.
Because I
and they're
changed it
infringing.
60%, so I'm okay.
Exactly. Or the other thing that we always talk about is the fair use thing, which I said last time, which is fair use is a defense. The insanity plea is a defense. You have to murder somebody to invoke the insanity plea. You have to infringe to invoke fair use.
so, I mean,
There you go.
but
still confused, if somebody does copy one of my designs and change it, they're still copying my design,
Design.
right?
yeah,
What is it,
but
made a change?
but is it
Yes.
but is it copying that triggers legal liability for them? I don't know.
How
Without,
do I prove that they've copied it?
well, there's
It's the legal
for
test.
copyright infringement, the thumbnail sketch of the legal test is there access to the work, and is there substantial similarity? Access to the work just has to mean it's out there in the public somewhere.
Well, yeah, it's on the internet, I have a website.
They may or may not have ever laid eyes on it. And
Exactly.
substantial similarity, I mean, if they can prove totally independent creation, then that can possibly get
Okay.
them off the hook. But substantial similarity, what does that mean? I don't know. Absent having a fact-specific situation and two things side by side to compare. And part of what courts will talk about and think about when they do the analysis is this: how many words, how many percentage, what part of the whole, blah, blah, blah. But there's not a set of magic guidelines that says the law is 10% change or more is okay.
Okay.
Good to know.
So,
I will correct everyone who tells me.
no.
Well, I exhibit at craft shows and everybody sees my design and they say, oh, this is fantastic, you copyrighted it.
Yes, you have.
Yes.
You came last week,
Yes,
right?
yes, I now I can say, yes, I have.
Right.
Because your copyrights arise at the
Oh.
moment of creation.
Exactly.